I'm Mike Corbin. I'm an employment lawyer. And I think in the interest of time, I'll keep it pretty straightforward. I think the first key, if you have employees, is to have a good and enforceable employment contract. A lot of people don't enter into employment contracts with their employees, nothing in writing at least, and that can lead to problems down the road. So, for example, and this will apply in all the provinces from which you guys are from, the common law in Canada is that an employee is entitled to reasonable notice upon termination. And that reasonable notice depends on a number of factors, like how long the employee has been with you, what their age is, what their position is, what their salary is, what the market is like to try to find a new job if you terminate them. Often, the common law can provide for about a month per year of service. So if you have had an employee for 10 years, and that person's 40 years old, that person may be entitled to 10 months notice of termination, which can be very expensive for you as an employer if you want to make a change. So one way to deal with that is to have a good employment contract that has a defined termination provision that says we can terminate you at any time without just cause by providing you with 3 months notice of termination, or by providing you with only what is required by the Employment Standards Act. So it can make it a lot less expensive for you as the employer if you do want to make a change, if you do want to terminate their employment without just cause.
Excuse me, does that have to be signed right up front? You can't implement that later on?
You can actually. So what you can do if you have an existing employment relationship but you don't have a good employment contract, or you're not happy with your employment contract, is you can introduce a new employment contract for the employee. You have to give that employee what's called fresh consideration in order to make that employment contract enforceable. That can mean anything from $10 to $25 to $100, but at least in BC, our courts have held that if you want to have a new contract for an existing employee, you have to give that employee fresh consideration. You should give that employee the right to go and seek legal advice about the contract before deciding whether he or she wishes to sign it, and sometimes a process of negotiation then ensues. But you can absolutely change the employment contract.
So the fresh consideration should be written into the contract?
Yes, exactly. Sorry.
And I don't understand what your $10, $100, what's that mean, an hour? Does that mean a gift, or?
That's what you're actually providing to the employee in exchange for the employee signing the contract. It's a one-time payment of $25 or $50, yeah. So fresh consideration means that you're actually giving an existing employee an amount of money in exchange for them agreeing to sign the employment contract. And as you indicated, you would have a clause in the employment contract itself saying the employer is hereby giving the employee $25 as fresh consideration to sign this employment agreement. And what it means, it gets back to the basics of contract law, that there has to be an offer, there has to be acceptance, and there has to be consideration. And if you have an existing employee, just continuing the employment contract is not consideration. That's why you have to give something over and above.
The same rules apply with contractor versus employee?
Well, no, it's different with contractors, but what sometimes happens is you may think they're a contractor, they may think they're a contractor until the relationship breaks down, and then they say, well, in fact, I was an employee. I came to work, Monday to Friday, 8 hours a day, 40 hours a week. 90 or 100% of my income came from this relationship. I'm actually an employee. So it's not the question that you asked, but a question that does often arise is the person really a contractor, or are they really an employee?
What defines that boundary? Is there a certain amount of hours or a certain percentage of income?
Well, there are different tests that apply in different areas. So for tax, there are different tests. For workers' compensation, there are different tests. For employment standards, there are different tests. At the common law, there's different tests. Basically, the way I look at it is if it walks like a duck and talks like a duck, it's a duck. And often I see people being characterized as contractors when in fact it's really an employment relationship. And there are risks in not treating somebody as an employee when they are in fact an employee. Sorry.
What if you want to do a new contract on an existing one and you offer fresh consideration, they say no?
Yeah, and then that does sometimes happen. And then sometimes, and this is part of the advice that goes back and forth even with the lawyers, is does it make sense to try to introduce this new contract into the employment relationship? Because if the employee says no, then you're kind of at okay, what do we do now? Do I terminate the employee without just cause because they won't sign the new contract? Or do I have this one employee on a different arrangement than the other 12 who did sign? It becomes a bit of a tricky issue with the existing employees, for sure.
If you have just cause, do you need to pay that 10 months, for example?
So no, we'll come to that. So basically, if you do not have just cause, then you have to provide reasonable notice of termination unless you have a contractual provision that says you get this much. Then you don't have to provide reasonable notice, you have to provide the contractual amount that you've agreed to, as long as the contractual amount meets or exceeds the employment standards requirements in whichever province you are operating in. I'll come now to I'll go to just cause. Because if you have just cause for termination, then you don't have to pay anything. And that's because the courts will say, well, it's the employee's own misconduct that breached the employment contract. But just cause is very difficult to establish for employers. To establish just cause, and I'm sure Mike will have examples of this in his business, you have to establish that the employee engaged in very serious misconduct that essentially breaches the essential foundation of the employment relationship. And so it's not a light thing to do to assert just cause. And before you assert just cause, I think you will want to make sure that you conduct a very fair and impartial investigation to, even though something may have come to your attention that causes you great concern about the employee's conduct, you're going to want to do a fair and balanced investigation, allow the employee to explain his or her side of the story, put all the relevant facts to that employee, and make sure that you have all the facts necessary to make that final decision of, okay, is it really just cause or is it not just cause? Some examples of just cause that are pretty clear are theft. If an employee who you trust is stealing from you, then that usually is just cause. But other than that, it's often a bit murky as to whether there is just cause. You may have an employee who you think has sexually harassed another employee, or has threatened another employee, and so you may be thinking right off the bat, hey, that's just cause for termination. But I would just caution you to make sure that you conduct a good and balanced investigation to get all the facts, and that you take advice from a lawyer before deciding whether to allege just cause, because that can be very serious.
And every experience I've had on that, it's always been figured it's just been cheaper to pay more up front, pay them off, see you later.
Yeah, and that gets back to the first point. One of the real advantages of having a good termination provision in the employment contract, and when I say good termination provision, I mean favorable for the employer, is that it is less expensive to terminate. And it's certain, and because one of the disputes that often does arise in a termination situation is, well, how much am I entitled to? How much is the employee entitled to? But if you know up front, if you've agreed up front that on termination you're going to get this much money, then there's no dispute about that. And if that's a relatively low amount of money that's going to be a lot less expensive than hiring a lawyer or fighting a just cause case, then it is simpler to just go that route. There's a story in the province today about a case that came down yesterday. A Cowichan First Nations band terminated a social worker. She may not have been a social worker, but terminated her when she got in an altercation at the bar off work, alleged just cause, and basically the employer was excoriated by the judge, said it clearly was not just cause. She got 24 months notice, so 2 years of pay. She got $35,000 in aggravated damages. And there's a public judgment now saying that so-and-so and so-and-so and so-and-so from the employer were not telling the truth or were not credible. And it's just, that's a world you don't want to be in. And so if you have a good termination provision, then certainly in a closed case, you're going to want to probably err on the side of just paying the amount up front, because it's going to be cheaper and simpler in the long run. There are other provisions to include in an employment contract. James touched on some of them. With an employee, as the employer, you own the copyright, but you don't necessarily own the inventions. So if you're in a business where inventions are important, you will want the employee to agree that they assign basically their right in the invention to you, that you own that intellectual property as the employer. There are lots of other clauses that you will want to include, I think, in a good employment contract. One is confidential information, that you define what the confidential information is. It would include things like your financial records. It would include your business plans, your client lists, and the employee would agree that that is the employer's property and the employee can't divulge that to anybody at any time during or after employment. You will...
I have 5 minutes.
5 minutes. So you'll also want to think about things like restrictive covenants. And by restrictive covenants, I mean non-competition clauses, which can be very difficult to enforce, but non-solicitation clauses, which can be more easily enforced. And so the difference between the two is a non-competition clause with your veterinary business, for example. You may want one of your vet employees to say, hey, I'm not gonna work as a vet anywhere within 100 kilometers of here. That can be difficult to enforce, for sure. But a clause which says, okay, I will not try to solicit any of your clients if I am a vet somewhere else, that is more reasonable, and that is something that the courts will more readily enforce if it's reasonably drafted, both in terms of the time that it applies, the geographic region that it applies, and the area of business. But so a non-solicitation clause that sort of protects your clients from being poached is something that is more readily enforceable than something that says you can't go out and earn a living in your chosen field. Courts are very reluctant to enforce those. This is sort of an emerging area, like appropriate use policies. I don't know if any of you have had examples where your employees are using your computer system, your emails, your social network, anything, using it inappropriately to either, download or send emails of pornography or gaming websites, or sending your confidential information, or doing things that you think are inappropriate on your system. I think it's really beneficial to have a policy that says the employer owns the system, and we have the right to monitor anything that you're doing on the system, and that you're prevented or prohibited from using our system for any inappropriate uses which you would then define. And you would want to make sure that that it's clear to the employee that they don't have a reasonable expectation of privacy in what they do on your system, because otherwise you can get into a bit of a murky world of, hey, this is my private information, this is my personal information, even though I'm doing it on working time and on your system, employer, I say you can't look at it. So it's a bit of a murky area and an emerging area, but I think it's a good advice to have an appropriate use policy.
Is this something that, because we already have an employment contract and a confidential contract, so this portion of it would be new. Is this something new that you can give without it being a contract, but
Yeah,
here's a
new
rule
policy.
A new
Yeah.
policy, please sign and submit?
Yeah, I mean, I think it'd be better if it was incorporated into a contract, but I think that's not a bad idea. You will have other
For
policies.
future people, we could do this, but for people existing.
Exactly.
And do we have to do that? I forget what it's called.
A fresh consideration? No, I don't think so for something like this. There will be other policies that you may have that don't form part of the employment contract. Like, for example, you're required to have a privacy policy, at least in British Columbia. I don't know if all of you do, but you're required to. You're a privacy policy under the Personal Information Protection Act. Everybody is now required to have a work-safe bullying and harassment policy in British Columbia. And so these are policies that you can have that don't form part of the employment contract, but that apply to the employees. I don't know what it's like in Alberta, in Saskatchewan, and Ontario, but yeah.
Can I ask of my employees to not put that they work at my clinic, orchard veterinary care or something like that? Because, and I don't even know if I should be, because if they go, oh my God, I dealt with this dog that had horrible diarrhea all day, we're a small community. It's pretty easy to figure out who did it. Like if that client sees that post, because there's so much overlap, and if they're going, oh, this dog was just horrible in the back, I don't want that on there. I don't want it linked to me.
Yeah.
So,
Yeah,
okay.
you can tell your employees, don't do that.
Can I do it just verbally, or should
Yeah.
I have that written down?
You can do it verbally, and then if there's a problem, then I think you could go Ava's route and have a meeting with the employee and say, look, we talked about this. I asked you or told you not to do this, and you've done it. So I'm serious. I want you to stop doing it. and
Can
sort
you
of
tell
doing
them
that.
things that they're not allowed to talk about on social media, or more only restrict them from saying that they work or disclosing that they work at your establishment?
No,
Or
you
can you do both?
You can do both. You can do both.
Or talk about clients. I had one time
Exactly.
somebody posted, had a shit day at this site, and,
Right.
it was and they named the site, and I take that
Right.
off their whole
Right,
with a
exactly.
picture, like,
You can, now it has to be reasonable, but if you're doing things that you say, look, to protect to protect my business, I want to prevent you from talking about our clients
they
in social
they just
media.
Does
unfriended
that
me.
fall
after-
under appropriate use policy, or does that fall under privacy? Does that
It could fall under, you could deal with it in the appropriate use policy for sure. Like don't
social-
discuss clients on social media.
rules,
Yep.
okay.
Yep.
You have to
Right.
hammer those people. Like you have to hammer them every single day. Like we have a huddle every morning at 10:45 that everyone's together, and their privacy gets reminded every single day because people need to fresh examples to just everything is private,
Yeah.
all of it.
Mhm.
Because signing the policy is all good, but people forget, and young employees, they don't connect the dots between it's Facebook, it's different, it's just my private things.
No, it's,
Yeah.
Try to reinforce it every single day with different scenarios and examples. So they kind of they get it.
I think that's really good advice. Especially a lot of American companies love to have sort of employee handbooks, and sometimes they're great, but sometimes what happens is the employer doesn't follow their own handbook when they're doing an investigation, and then that can come back to haunt you. If you're now in litigation and an employee is suing you and you haven't followed your own handbook, the judges kind of look at you a bit askew, like you're complaining about the employee not following the rules, but you're not following your own rules. So generally, I like to have as much flexibility as possible for employers who are our clients, not to tie them down when you don't need to. So a big, expensive employee handbook that nobody ever reads and is honored more in the breach than in reality can actually be a drawback.
What about these things that you say, just have policies, like one-page policy?
Yeah.
Saved on your computer?
So you could have a little policy book that you give to the employees that contains sort of an appropriate use policy, privacy policy, a bullying and harassment policy, and any other policy that, like if you wanted to have a social media policy, you could. Any policy that you wanted to protect your legitimate business interests, you could have a little policy book, provide that to the employees, and have the employees acknowledge that they've received that and that they've read it and that they will follow it.
You guys, we
You
have
could do
1
that.
minute, and we really don't, but we have 1 minute because I
So
want us to
that's last slide, and I don't know whether Mike would agree with this, but usually, if you're getting that sort of spidey sense that hey, something's going on here, I should get advice. You should get that advice sooner rather than later. Often, if you wait too long, it is going to be a much more expensive and difficult problem to solve than if you get advice earlier. So I would just follow your spidey sense. If you feel like you need advice, you should pick up the phone and get that advice.